Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about an article that was in the Edmonton Journal, and the headline is Edmonton Landlords Run Do Not Rent List with Hundreds of Tenants in Private Facebook Group. Now, I'm not going to go through the full article. I'm going to link it in the description below. You should check it out. It's a good article. But what they're talking about here is Facebook groups that are being run by landlords for the purpose of telling other landlords that they shouldn't rent from particular people. And they look at one such group in this article. They did a follow-up where they looked at several more. There's probably dozens and dozens of these operating in Alberta here. Now, in some cases, they identify some reason for why people shouldn't rent to this particular person. They might say this person did damage, or this person was a nuisance, maybe a lot of noise complaints or something like that. Or, this person didn't pay their rent, those kinds of things. But many of these entries out there just say nothing. They just have the person's name and maybe some of their contact information, and they say don't rent to this person, but there's no details as to why. Now, I posted about this on Twitter, and a lot of people were saying, well, what's the problem with this? What's the big deal? And the issue is that this almost certainly violates Alberta law, and in particular, the Personal Information Protection Act. So we're going to have a little bit of a look at the act, see what it says, and talk about that. There are some other issues that come up, and some of these are legal issues, and some of these are practical issues. In terms of the practical issues, one thing that always happens with these kinds of lists is that they become contaminated with bad information. And there's a couple ways that can happen. The first way is that you can have people who are trying to make a good report, but that they might not be in the right. They might say this particular tenant owes me hundreds of dollars in rent, but maybe they actually got paid, and the landlord is keeping bad books and hasn't realized this, but the tenant is actually in the right there. Or they might say this person left damage behind, but it turns out that damage was actually from somebody else, pre-existing damage. So this is one source of bad information. And if that page repeats it, then you can end up with some difficulties there. But another source of bad information is just outright bad actors. Let's say you've got somebody who goes onto one of these things and they've just been in a really messy breakup. And so they are angry at their ex, and they're a bad person, and they're willing to do things to harm their ex. And so they might go and they say, don't rent to this person. But really the reason is just because it's their ex, and they want to cause them, suffering. And now that ex is finding it very difficult to rent a place, and they don't know why. So this is another source, and you might say, oh, this is far-fetched, but this always ends up happening with these kinds of lists. Somebody is going to abuse it because there are manipulative, abusive people out there. So the next thing I'll want to look at here is the Personal Information Protection Act. And this is one of the big problems for these kinds of groups here, because as I said, this is probably illegal. And the article themselves identify this, but they're not going to go, they don't, go and do sort of a deep dive into it. So let's have a look at the act itself. And there's a few things I want to start out by looking at. And one of them is the definition section, because if you watched this channel before, you know that I'm a big proponent of reading the definition sections. If you want to understand what terms mean in legislation, you have to check the definitions. So one of them in this particular case is actually kind of a tricksy definition. It's one that that has a meaning that you might not otherwise suspect or expect. So let's have a look at that. So this is again from the definition section, and it's for an organization. Organization includes A, a corporation, B, an unincorporated association. So far, so good, right? These sound like organizations. A trade union, as defined in the Labor Relations Code. A partnership, as defined in the Partnership Act. And then here's the surprising one. And here's the one that I know people would be in my comments going, you're wrong about this if I didn't specifically explain it, because it also includes an individual acting in a commercial capacity. So you can be an organization of just one person. It's actually really easy here. It doesn't include an individual acting in a personal or domestic capacity. But if you are a landlord, then you're acting in a commercial capacity. You're engaging in a transaction for money, and so you will count as an organization for the purposes of this act. And they also note that personal information means information about an identifiable individual, so one specific person. So definitely the kind of information that we're looking at here, because when they're saying you shouldn't rent to this specific person, that's going to be personal information. Now, the Act has a bunch of clauses that are worth looking at here. One of the important ones, because this is something that does come up at times, says, this act applies notwithstanding any agreement to the contrary and any waiver or release given of the rights, benefits, or protections provided under this act is against public policy and void. And the reason why I mention this is that sometimes businesses have tried to put in something to say, oh, well, by agreeing to do business with me, you're giving up your rights under the Personal Information Protection Act. This clause here says that you can't do that. If you put in a clause that says that, that somebody's not going to enforce those rights against you, that is considered void for public policy, and that clause is going to be struck. So you just can't do that. Don't even try. That's a really sort of important aspect here. Now, the next thing is in terms of consent. So consent is required for a whole lot of activities. And that includes if you want to collect information about an individual, or if you want to collect information about the individual from a source other than the individual, or using that information, or disclosing that information. All of these things require consent. And consent can be verbally or in writing. However, it does have some limits. One of those is that you cannot, as a condition of supplying the product or service, require an individual to consent to the collection, use, or disclosure of personal information about that individual beyond what is necessary to provide the product or service. So an example of necessary to provide the product or service would be, let's say I am signing up for a magazine subscription. I know magazines might be a little old-fashioned, but let's say that's what I'm wanting to do. I would then, I'd have to provide some information to that subscription company so that they could, for instance, have my address and know how to send me a magazine each month. I'd also need to potentially have them consent to disclose that information, because they might not do their own delivery. They might subcontract that out to another delivery company, and then they would need to provide my address to that delivery company, because otherwise I'm not getting my magazines, right? So that's examples of things that are necessary to provide the product or service. However, your landlord shit-talking you online later is not necessary for them providing the product or service of a place to sleep. So that is going to be a problem. They can't require that you consent to this. And in fact, it's pretty certain that these landlords aren't getting consent. None of these landlords are going up to these tenants and saying, hey, listen, I think you are a really bad tenant, and I would like to post some mean things about you online. Are you okay with me doing that? Because, of course, the tenant is not going to say, yeah, that's fine. So obviously they're doing this without consent. You can also give consent subject to any reasonable terms, conditions, or qualifications established, set, approved by, or otherwise acceptable to the individual. So the individual actually has a lot of power to limit that consent as well. All right, so all of these are sort of some critical provisions, but and I'm not going to go through all of the details about, when you can withdraw consent and so forth, but there are also aspects in terms of collection of personal information. You can collect personal information only for purposes that are reasonable. They do actually define what reasonable means in the definition section, but it basically is defined as reasonable. So that's not going to be super helpful. I didn't go through that definition for that reason. And where they collect personal information, they can do so only to the extent that it is reasonable for meeting the purposes for which the information is collected, which means that you can't use information that you collected for one purpose for a different purpose entirely. There's also big limitations on the use of it, as well as critically the disclosure of personal information, because that's really what we're talking about here when they go on these Facebook groups and start sharing this around. They can disclose personal information only for purposes that are reasonable. And again, they'll require consent for all of this. And where an information discloses personal information, they may do so only to the extent that it is reasonable for meeting the purposes for which the information is disclosed. Now, there are provisions that allow them to do disclosure without consent, but we can go through those really quickly, and you can see that it's probably not super helpful. So one is that it's clearly in the interest of the individual and consent cannot be obtained in a timely way. It's not going to be clearly in the interest of the individual for you to smack talk them online for the purpose of telling other people to rent from them. So that's not going to be an option. The next one is if disclosure is authorized or required by law, which again, not the case here. Disclosure of the information is for a purpose for which the information was collected, pursuant to a form that is approved or otherwise provided for under a statute of Alberta or regulation of Alberta. We don't have that applying here. To a public body, and that public body is authorized. Well, this is not a public body. This is just a Facebook group. It's necessary to comply with a collective agreement. Doesn't apply. Audit or inspection doesn't apply. Again, audit or inspection aspects. Treaties aren't, landlords, there's not a whole lot of treaty issues around landlords. For the purpose of complying with a subpoena, warrant, or order, again, not the case. To a public body or law enforcement agency to assist with an investigation, not the case here. Responding to an emergency, contacting next of kin of an injured, ill, or deceased individual, necessary to collect a debt, publicly available as prescribed or otherwise determined by the regulations. And this one gets complicated because this information is almost certainly not publicly available as defined by the regulations. I'm not going to get into the regulations here. I'll just sort of state that because the regulations are somewhat long. But yeah, they list a sort of specific set of things, and quite frankly, it doesn't appear that this is likely to fall under that. So the issues, if you violate this act, if you're an individual, the fines, I think, go up to $10,000. And if you are not an individual, if you're, a company or something like that, then it goes up to $100,000. So that can be very expensive. The other thing that could be very expensive is, let's say you post something about a tenant there and it later proves to be false. Or let's say you take one of those lists that you find and you share it to another place and it turns out to be false. Well, now you're potentially running the risk of, a defamation lawsuit, because now you're sharing information about a person that is causing them harm. And in fact, causing them harm is the whole point, right? You want to make sure that it's harder for them to rent a place. If you're not 100% accurate, you're running into some real potential difficulties in terms of the, defamation issues. So if you're a landlord and you're participating in these kinds of groups, there's some legal risk there, and you might want to talk to a lawyer before you do anything along those lines. I can't offer any sort of legal advice here because this is just a YouTube channel. You'll want something specific to your situation. And yeah, it's just, you got to be aware that there is legislation and there is law that applies to these kinds of behaviors so that you don't, run afoul of it. And you might disagree with this legislation. You might think that these groups are perfectly appropriate or whatever else. That doesn't change the fact that there are laws that apply. And one of these groups actually had a lawyer who was one of the admins of it and posted, I'm not going to sort of read out the name, although it is in the article, but the one of the posts there was, for those members that are continuing to provide legal advice, please stop. If you know what the law is and you are 100% sure, then fine, please share. But if you got your law degree on Facebook and don't know what you're talking about, please, I beg of you, defer to the professionals, or at the very least, those that know the law. Know that if you make a wild legal claim, and I see it, you better be able to back it up. That way we can all benefit from knowing exactly what the law is. The point of this page is to help one another with problems related to being a landlord or property manager. Let's all try to work together rather than against one another. And it continues on saying, regarding privacy of Facebook profiles, they are public, shared information or information which you have no expectation of privacy, have very little, if any, entitlements to privacy. That's probably not correct. He's probably got to read the act there. But it continues on. Regarding posting information, this page has rules which establish that you must prove that the tenants were in the wrong or caused damages. You can't really prove that on a Facebook page because you're not giving the tenant the opportunity to reply. There is no court process here. You know, you can't prove anything when you're just making allegations that the other person doesn't have a chance to respond to. So, yeah. And then it continues, RE non-landlords / non-property managers, get off this page. You agreed in the rules upon signing up that you were a landlord, property manager, or tenant. All members agreed to keep the discussions of this page private. If you are in breach of these provisions, you will be held accountable in civil court for breach of contract for any and all damages. This includes those that lie or make misrepresentations about tenants. Yeah, I'm not sure what damages you'd have for somebody signing up to the page when they're not authorized to. And then they sign it with their name and then barrister and solicitor, which is kind of a bold move. I'll just leave it there. We'll say it's a bold move. But I will note that apparently this they reached out to this person, the admin of that page, to ask them about that post. And they said that they had no recollection of the post and suggested someone else may have posted under his name, which of course is kind of difficult because when you look at the post in the article, it actually has the admin tag on it, so they would have had to post using his account. Pro tip out there, never do anything online that you might later have to claim I was hacked about. Just a tip. So regardless, when you've got, you might say, hey, there's this lawyer who's posting and saying that this is all cool, so this is, a fine list, except that lawyer is already having to walk that back and to say that they were hacked. And maybe they were, or maybe they weren't. I can't say for certain, but I will say that if they are backing away that fast from that post, maybe it's not something that I would super rely on. So I have had this dispute with, I actually had an argument about this with some other lawyers who were saying that they thought this page was fine. I don't think it is, and I will note that the article also quotes some privacy law experts who are saying that they don't think it's fine either. So just a thought, this is something you may want to consider not doing if you are out there. Talk to a lawyer if this is, your situation, but it is, I think, a fair statement to say that these kinds of pages are legally problematic. They're legally risky, and you got to decide what kind of risk you take, but talk to a lawyer if that's something you want to venture into. Anyway, yeah, people wanted to know what the issue was with these things, so that's really what the issue is. The law says you can't use that kind of information against people later down the line. Anyway, thank you for watching. I hope you found this to be interesting or educational. Please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters. At the $50 level, Canada's National Firearms Association, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Mick Tane, Mark, Jane Babin Luxor, Haywire, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Vicky Shefchik. I hope I've got that right. Please let me know if I didn't. I also want to thank everyone at the $10 level who will be in the crawl immediately following. Thank you for watching, and I hope this has armed you with knowledge.